Got a question from a landlord asking their tenant is parking their vehicle in an unauthorized manner against a municipal ordinance. In this case, it was like parking on the front lawn and it violates the municipal ordinance. This owner's getting fined by the municipality. They're asking, what can they do? Can they tow the vehicle? What should they do? Hi, my name is Rob Wells. I'm the Landlord on TikTok and YouTube. Please feel free to like, share, subscribe to our videos. Now, we get this situation kind of a lot where a tenant is not doing what they're supposed to be doing under the rental agreement. They're violating a local municipal code. And in many places in the Bay Area and probably elsewhere across the state, you may not be able to park on in your front yard, basically, on like the lawn, for example, that the ordinance deems it like a public nuisance. And in this factual situation, the landlord was actually starting to receive fines and fees from the municipality, and it had gone on for quite some time. And this landlord was like, what do I do, Rob? Do I tow the vehicle? Do I give a certain type of notice, etc.? And, I tell this landlord, okay, so pursuant to the vehicle code, we've talked about on the channel how how a landlord can tow a vehicle from the vehicle code 22658. That actually wouldn't apply in this case because the tenant is actually in possession of the property, okay, in this scenario, okay? The tenant is in possession of the property. I think it was like a single family home, and this landlord asked, could you tow the vehicle? I said, absolutely not, because the tenant controls the vehicle, okay? Now, if it was like in a common area, that type of deal that the landlord controls, the landlord could initiate the tow, but pursuant to vehicle section 22658, it's whoever has lawful possession, okay? So when you rent out like a, particular property, a single family home, usually the tenant gets everything, the yard included. No tow, okay? So what does a landlord do when they can't tow a vehicle legally? Well, in a lot of written leases, I'm hoping, and I kind of tell people, make sure you have the right provisions in your lease. Tenant can't cause a nuisance or violate laws, okay? And in this scenario, this landlord had a, hey, can't cause a nuisance and, violate laws and ordinances, etc. here. So the proper remedy would be to issue that tenant a 3-day notice to perform to, cease and desist parking in violation of the municipal code. Okay. And if the tenant doesn't fix it, then they could be subject to just cause eviction, from my Tenant Protection Act landlords, subject to the act, you're going to have to give 2 notices. You're going to have to give a warning notice to the tenant saying, hey, this is a lease violation, can't violate, the municipal code and, causing us to get fined, etc. here. Move your vehicle. If not, we're going to give you a 3-day notice to quit. If you're an exempt landlord and if the tenant doesn't fix it within 3 days, excluding weekends and holidays, they're subject to eviction. Okay, so that would probably be the proper remedy to deal with that situation. And the moral of the story is it's best to have provisions in your lease that say you got to follow all ordinances, not cause a nuisance. And also, too, if this landlord gets fined because of something the tenant causes, that's subject to reimbursement upon demand of the landlord. That'd give us another 3-day notice to perform grounds. If in this case, this landlord got fined, I'm going to send you the fine, tenant. I got fined for your behavior, so now you have to reimburse me for that type deal. So, landlords, if you're facing that type of scenario, the best thing to do is to act when you become aware of the problem and not let it go away. Tell you a little secret. A lot of these municipalities won't fine you if you let them know that you're addressing the problem. Particularly, you're going to issue the requisite notices and so forth like that. A lot of municipalities have these, new ordinances to just, keep the neighborhoods, in good order and, not, have public nuisances or attractive nuisances, that type of deal. They will work with you if you reach out to them. If you ignore them, then that's when they start adding the fees and so forth. So best to act quickly. If you're a landlord facing this type of situation and you're in the Northern California area, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.